So not everybody. So welcome, all of you who are just now chiming in. Welcome, welcome. We are so blessed to have each and every single one of y'all in the building tonight. So we were just talking about the Do for Self retreat, October the 16th. You do not want to miss it, okay? I just put a coupon code for $100 off. Anyone who does not have your tickets and you want an extra $100 off, I just put a code in, Big Bully in all caps. Thank you, Diamond. Let's see. So we are
and we have moderators. You know what? For the moderators that's in the chat, can you change the beginning of your name to MOD so that people know when you're speaking that you're a moderator? Just put MOD on the front caption of your name so that people know that you're a moderator. We have moderators that's in the chat that are answering some questions for you guys. They are here to have our back.
That's right. As
Peace and love, peace and love. Welcome for everybody who's just coming in. Drop some I love myself in the chat. We're going to get started here shortly.
Listen, and again, y'all, if y'all think tonight, when you guys see the experience is tonight, I hope that gives you a glimpse into what we about to do in this retreat for 3 days. Like, oh, Sophia, you got Sophia.
Oh, look, I'm about to grab my Red Bull, take some vitamins.
Yeah, forget your sleep. We finna dive in.
Definitely get your sleep. Definitely. So it's a little bit after 8. And we'll be getting started here shortly because we definitely want to respect everybody's time. Yes, yes. I love myself. All right. Did the screen freeze or did we just get real quiet? I think we just got real quiet.
I think we just got real quiet. I think we got real quiet.
Yeah, we got real quiet for a second. We're multitasking. So we're in here, we're making sure everything in the back end is as it should be, and everybody who paid can get in.
That's right.
And let's see. I know Geneva, who is one of our moderators, is in here. If our brother is ready, you can tell him we are ready when he is.
I'm super excited.
Super excited. So in case they don't know, Diamond, we're asking the moderators to, if you could change your name to add MOD at the beginning. So people will know that you're a moderator when you're answering their questions or helping out in the chat. Diamond Jones is a moderator. Geneva Queen Bee is a moderator. Who else we got in here?
Is he ready?
I am waiting on the word.
So as we're waiting for him to come in, so we're just going to remind you all of housekeeping rules. We do not allow any recording whatsoever. Please, please, please not record. If we catch you recording, we will block you. We will not give you a refund, okay? The other thing is, when you understand a point and something really, really resonates with you, we need you to go to the chat and I love myself. I love myself. I love myself. And last but not least, this is legal information. This is not legal advice. You are in need of legal advice. Seek a licensed bar attorney. We are not it. We are here for advice, not advice, for legal information only.
Okay, if you're not muted, we're gonna need you to mute your phone.
Hey.
Somebody is definitely not muted. Okay. I don't know who that, I think that was, I'm not gonna say who I think it was, but just make sure your phones are muted, okay? Renee, you gotta unmute yourself. All right. All right. Coming to the stage. No. So like I said before, we have our very new team member, our brother Jesse. He's also known as Duke the Credit Beast. He is not new to the game, he's just new to the team. I have never heard anybody break down the FDCPA like how he does. If you've never heard him teach, you are definitely in for a treat. Not only will you have a better understanding of the FDCPA, you should be able to walk away and get busy. Without further ado, if you're ready, our brother Jesse.
Hey, what's up, everybody? How you guys doing? Hope you guys just as excited as I am. This class is going to be beneficial whether you've been studying or you're new to the game. It really doesn't matter. I'm going to break it down as simple as I possibly can, so all of you guys are going to walk away with clarity. Let's see. I'm not going to be able to see the chat. The mods are going to be handling the chat, so I'm going to be going through strictly just teaching. But if you guys are ready, I'll get straight into it. What do you guys think? So I get straight into it.
Let's go. Real quick before you get started, if everybody, you can feel free to turn your cameras off. That's fine. And we'll definitely get started. Remember, if you raise your hand before question and answer, we'll put them down. Hold all your questions until the end, and please keep yourself muted until we call your name to ask a question, and then you can unmute yourself. All right, the floor is yours, brother.
All right. Let me open up. Give me a second. Sorry. Can everybody see my screen? Make sure.
Yes.
All right. So this is the Fair Debt Collection Practices Act, 15 U.S.C. 1692, the congressional findings and the Declaration of Purpose. What this section is telling you why we are here, why these laws were passed, and why they were created in the first place. So let's get right into it. Abusive practices. There is abundant evidence of the use of abusive, deceptive, and unfair debt collection practices by many debt collectors. Abusive debt collection practices contribute to the number of personal bankruptcies, to marital instability, to the loss of jobs, and to the invasion of individual privacy. B, inadequacy of laws. Existing laws and procedures for redressing these injuries are inadequate to protect consumers. So the previous laws that existed were not good enough, so they had to pass these even stronger protection. Available non-abusive collection methods. Means other than misrepresentation or other abusive debt collection practices are available for the effective collection of debts. Interstate commerce. Abusive debt collection practices are carried on to a substantial extent in interstate commerce and through means and instrumentalities of such commerce. Even where abusive debt collection practices are purely intrastate in character, they nevertheless directly affect interstate commerce. So even if they're within only one state, they directly affect interstate commerce. Commerce just from state to state, that's all the same. So here we go, the purposes, right? Why is it passed? It is the purpose of this subchapter to eliminate abusive debt collection practices by debt collectors, to ensure that those debt collectors who refrain from using abusive debt collection practices are not competitively disadvantaged, and to promote consistent state action to protect consumers against debt collection abuses. So look at what is said right there. The purpose is to eliminate abusive debt collection practices. And once we go deeper into this, you're going to see almost every single thing they do is abusive. So in other words, it's saying it's time to eliminate these debt collectors, eradicate, remove. They will no longer exist. And pay attention right here where it says abusive practices, and it mentions that it's invasions of individual privacy. Notice that that is not defined, because nobody can tell you what is private to you. Just think about in your everyday life, when you have people, you ask them questions, and yeah, some people, oh, like an open book, they'll tell you the whole life story. Then you have some other people, you can't even ask them what they did yesterday, because people's privacy is private to them even. They decide as a natural person what your privacy is. From there, we're gonna get straight into A, which is definitions. Now, the reason why I like the FDCPA, and this is where I recommend everybody start, because there's only 8 definitions. Every other act, there's a lot more, but I want you guys to pay attention as I go through these. There's 2 terms that these banks love to use when they describe you and describe what they gave to you, right? This entire act has to do with debt collection, strictly debt collection. So I want you to pay attention, and I'm going to tell you what 2 words are missing. 1, the term bureau means the Bureau of Consumer Financial Protection, otherwise known as the CFPB. Notice that it does not say Equifax, TransUnion, Experian, because they're not bureaus. If you look at the FCRA, it tells you exactly what they are, and they really ain't nothing. They try to use the term bureau to make themselves seem more important. 2, the term communication means the conveying of information regarding the debt directly or indirectly to any person through any medium. So pay attention when you see the word or, because as a natural person, you have the power to choose which one. Pay attention to the word any, because it literally means any. There is no limitation to it. And medium is just another medium, a form of, right? A form of communication that could be through the phone, through the mail, Facebook, however it may be. The term consumer means any natural person obligated or allegedly obligated to pay any debt. So pay attention again, or allegedly, right? They have to prove it. I always say that things are alleged. They have to prove it to me. The term creditor means any person who offers or extends credit creating a debt, or to whom a debt is owed, but such term does not include any person to the extent that he receives an assignment or transfer of a debt in default solely for the purpose of facilitating collection of such debt for another. So of course, that would be your third-party debt collectors, even though I say they're all third-party. Now look at your retail installment contract. It tells you who it was assigned to, that it was assigned to somebody, and that's the person that strictly just sends you bills to collect from you. Right here, it's saying they're not a creditor, right? The term debt means any obligation or alleged obligation of a consumer to pay money arising out of a transaction in which the money, property, insurance, or services which are the subject of the transaction are primarily for personal, family, or household purposes, whether or not such obligation has been reduced to judgment. So pay attention to personal, family, and household purposes, because you see that in truth in lending as well. And notice again, the word or is saying any obligation or an alleged obligation. Even if it has been reduced to judgment, it is still an alleged obligation. Pay attention to that. And I'm going to show you why when we get deeper in, we get to 1692G. I got a couple more gems for you too. Once we get to 1692G, I'm going to jump to truth in lending to show you guys a little something. The term debt collector means any person who uses any instrumentality of interstate commerce or the mills in any business where the principal purpose of which is the collection of any debts, or who regularly collects or attempts to collect directly or indirectly debts owed or due or asserted to be owed or due another, notwithstanding the exclusion provided by F. But pay attention to the very first sentence. any person, there is no limitation to the person who is using any instrumentality of interstate commerce, who is doing business through interstate commerce, or using the mail, sending you bills and attempting to collect. So any person who attempts to collect any debt regularly is a debt collector. The term location information means a person's place of abode and his telephone number at such place or his place of employment. So you notice it doesn't say resident when it's talking about a consumer. A natural person has a place of abode. That is your location information. Now, the term state means any state, territory, or possession of the United States, the District of Columbia, the Commonwealth of Puerto Rico, or any political subdivision of any of the foregoing. So like I said, there was only 8 definitions. Now, this act talks strictly about debt collection. Why does it not mention a borrower? And why does it not define a loan? Is it because you're not a borrower? Is it because you didn't get a loan? That's what I believe, right? And that's what the law says as we get deeper into it. Truth in Lending and FDCPA together, you are not a borrower. It is not defined in the FDCPA. They did not give you a loan. It is not defined in the FDCPA. This is just the definition section. This is where you guys need to focus and pay attention, because this is the verbiage that you need to be using. Let's go next. B, acquisition of location information. Any debt collector communicating with any person other than the consumer for the purpose of acquiring location information about the consumer shall. Now, when you see the word shall, that means they must, they have to, right? These things need to be done. They have to, 1, identify himself, state that he is confirming or correcting location information concerning the consumer, and only if expressly requested, identify his employer. So they're supposed to be confirming or correcting. Why do they ask you to give them the information? If you're confirming it, you should not be requesting it from me to provide to you. You need to tell it to me so I can confirm it that you're correct or not. And look at right here. Number 2, not state that a consumer owes any debt. So why can't they say that you owe a debt? Just by saying that, that's a violation. Not communicate with any such person more than once unless requested to do so by such person, or unless the debt collector reasonably believes that the earlier response of such person is erroneous or incomplete, and that such person now has the correct or complete location information. So they're not supposed to communicate with you more than once unless you request for them to do so. Now, I don't know about you guys, but I have never asked them to call me back. Not once have I said, oh, please keep calling me. Please call me 4 more times before the day is over. Not one time have I done that. Not communicate by postcard. That's number 4. They can't even send you a postcard. They cannot send you anything in the mail. That's a violation. Not use any language or symbol on any envelope or in the contents of any communication affected by the mails or telegram that indicates that the debt collector is in the debt collection business, or that the communication relates to the collection of a debt. So right there, right? Imagine they put their logo on everything. The envelopes have their logo. The letter inside has their logo. So their logo on the envelope, you don't even need to tell me what it is. I could walk in somebody's house and so can you. And if you see a logo from Edison, you see a logo from the gas company, from Verizon, no matter who it's from, when you see that letter, you know that it is a bill. They already indirectly communicating with how many people: the mailman, the mail sorter, your neighbor, if they saw you getting your mail, your friends, if they come over to your house. All of those people were indirectly communicated with just by them having a logo, which is a violation. After the debt collector knows the consumer is represented by an attorney with regard to the subject debt and has knowledge of or can readily ascertain such attorney's name and address, they cannot communicate with any person other than the attorney, unless the attorney fails to respond with a reasonable period of time. So what it's just saying is if you have an attorney and they know they're supposed to contact the attorney only and not you. Let's go, next one. Every time I get on here, it starts acting up on me. Let me go right here and go to C. All right, let me see, I can't help it but to look at the text. Let me get away from it. I know Renee's gonna get mad. Let me get away from it. Communication with the consumer generally, pay attention, without the prior consent of the consumer given directly to the debt collector or the express permission of a court of competent jurisdiction. A debt collector may not communicate with the consumer in connection with the collection of how many debts? Any single debt, any debt, without your direct permission given to them. They cannot communicate with you. So let's see right here too. They cannot at any unusual time or place, or a time or place known or which should be known to be inconvenient to the consumer, in the absence of knowledge or of circumstances to the contrary. A debt collector shall assume, right? That doesn't mean that they're correct. They're just assuming that the convenient time for communicating with the consumer is after 8 o'clock a.m. or before 9 p.m. local time at the consumer's location. So I'm going to ask you guys, when is it ever convenient for somebody to call you and tell you that you supposedly owe a debt, owe this alleged debt? For me, it is never convenient. It doesn't matter what time of day it is going to be inconvenient for me. And you as a natural person get to decide, not them, not the corporations. They're just a piece of paper. If the debt collector knows the consumer is represented by an attorney, the same thing again, they have to communicate with your attorney. 3, at the consumer's place of employment, if the debt collector knows or has reason to know that the consumer's employer prohibits the consumer from receiving such communication. Now, the only way they can know if your employer prohibits that kind of communication is to first contact you, which is inconvenient, again, still a violation. And if you're self-employed, again, you don't allow that at your employment, right? I'm self-employed. I'm working right now. They call me right now on my business line. I don't prohibit phone calls from debt collectors. Except as provided in 1692B of this title, without the prior consent of the consumer given directly to the debt collector or the express permission of a court of competent jurisdiction, or as reasonably necessary to effectuate a post-judgment judicial remedy, a debt collector may not communicate in connection with the collection of any debt with any person other than the consumer, his attorney, a consumer reporting agency, if otherwise permitted by law, the creditor, the attorney of the creditor, or the attorney of the debt collector. Ceasing communication, this is an important part right here. Everybody is out here buying templates, right? People are selling templates and people are buying templates for ceases and desists and all that debt validation, which we're going to get to. Excuse me. Ceasing communication. This is your template. Congress is your template. If a consumer notifies a debt collector in what? In writing, not over the phone. A lot of us do this over the phone, and then we wonder why they didn't abide by our cease and desist that we orally told them about. It must be done in writing. Congress is even telling you this right here. In writing that the consumer refuses to pay a debt, or that the consumer wishes the debt collector to cease further communication with the consumer, the debt collector shall, the debt collector must, the debt collector has to not communicate further with the consumer with respect to such debt, except, so these are the only reasons they can respond back, is to advise, we're not looking number 1, to advise the consumer that the debt collector's further efforts are being terminated. 2, to notify the consumer that the debt collector or creditor may invoke specified remedies which are ordinarily invoked by such debt collector or creditor.
Just put it on speaker since you already got it on.
Or, you go ahead and mute yourself, please. Or 3, where applicable, to notify the consumer that the debt collector or creditor intends to invoke a specified remedy. But you see that it's saying debt collector or creditor. We are creditors and we are debt collectors. We are the only lawful debt collectors. So you will let them know in writing that you can let them know that you refuse to pay the debt. You can let them know that you want them to cease communication with you. And you would say, pursuant to 15 USC 1692 CC 2, I intend to invoke my specified remedy, which is ordinarily invoked by such debt collector or creditor. What is your specified remedy? Is it to zero out the balance? Is it to grant you your title lien free? Is it to remove the report? Remove the account from your credit report? It is up to you as a natural person what your specified remedy is, but you must specify it. Always let them know whenever you send a letter of what you want them to do and what you want out of the communication as well. Always make sure you are telling them that. And right here, if such notice from the consumer is made by mail, notification shall be complete upon receipt. So on my letters, when I send them, I always put at the bottom, notification is complete upon receipt. You are officially notified now that you received it. Consumer defined. For the purpose of this section, the term consumer includes the consumer's spouse, their parent if the consumer is a minor, the guardian, executor, or administrator. So look at that. You're already an executor and you're already an administrator. You do not have to do anything special, but be a natural person. A natural person just means you naturally exist. You were born from your mother. You naturally exist here in this earth. You live, you breathe, you think, and you speak. You are an executor and an administrator already. No special steps need to be taken. Harassment or abuse. And the chat keeps getting in the way. 1692D. Let's get into it. A debt collector may not engage in any conduct. What is conduct? Conduct is behavior. So in any behavior where the natural consequence of which is to harass, oppress, or abuse any person in connection with the collection of a debt without limiting the general application of the foregoing, the following conduct, the following behavior, the following actions are a violation of this section. 1, the use or threat of use of violence or other criminal means to harm the physical person, the reputation, or the property of any person. So when they threaten that they're going to take your property, they threaten that they're going to report you as late to the credit reporting agencies, they're going to ruin your reputation. They are threatening your reputation. When they say they're going to repossess and they are threatening your property, who else uses violence to get you to do something? The use of obscene or profane language or language, the natural consequence of which is to abuse the hearer or the reader. So again, being the natural person, everybody is different. What's obscene and profane to me may not be obscene and profane to you. So saying that I owe a debt that I know I do not owe, that's obscene and profane to me. That's obscene and profane language. You telling me that I owe you something. That's a violation as well. The publication of a list of consumers who allegedly refuse to pay debts, except to a consumer reporting agency or to persons meeting the requirements of section 1681F or 1681B3 of this title. So when you go to court and you can see people right there, they have liens on their property. They're public, a list that they're publicly putting out there for people to see. Whoever refuses to pay a debt, that's a violation. So keep in mind, everybody, that just because it is against the law, it does not mean that it is not being done. That is the main thing we need to get out of our heads. It is against the law for someone to come in and break into your house and steal your things while you're not home. It still happens all the time. The advertisement for sale of any debt to coerce payment of the debt. So have they ever told you they were going to sell it to a third party to have them collect on you? They're attempting to coerce payment out of you. They tell you that they're going to repo your vehicle and auction it off. They're attempting to coerce payment from you. That is obscene and profane language. That is harassment or abuse. 5, causing a telephone to ring or engaging any person in telephone conversation repeatedly or continuously with the intent to annoy, abuse, or harass any person at that called number. So again, how many times are they saying without your permission, they can only contact you once? Or they can only contact you once without your permission. They were abusing and harassing you by calling you multiple times. And I know I've had it in the past where at 9 o'clock my phone rings, then at 9:10, then at 10, then at 12, and then at 1. It's like 6 calls in one day. And that's a harassment, that's abuse. They're in the same thing, coercing payment from you. And it says the placement of telephone calls without meaningful disclosure of the caller's identity. So they have to, this is the part though, they have to tell you why they're calling you, which is to collect the debt, and that any information they get is going to be used to collect in the collection. But by even telling you that, it's a violation. So that's what I mean. These debt collectors cannot do nothing. And we've been lied to so much that we've been told all this, how powerful they are, all these things they can do to us if we don't pay. It's all lies. Now, 1692E, this is my favorite section of the FDCPA. False or misleading representations. False or misleading can be fraudulent, made up lies, right? Representations, those words are synonymous with false and misleading. A debt collector may not use any false, deceptive, or misleading representation or means in connection with the collection of any debt without limiting the general application of the foregoing. The following conduct, the following behavior, the following actions are a violation of this section. 1, the false representation or implication that the debt collector is vouched for, bonded by, or affiliated with the United States or any state, including the use of any badge, any uniform, or facsimile thereof. Who do you know that wears a badge and a uniform and tells you that you're obligated to pull over on the side of the road and tries to collect the debt from you? It's saying here that by doing that, that's false and misleading. This is very powerful. 2, the false representation of the character, the amount, or the legal status of any debt. So the character and the amount. So if it's positive, right? So everyone thinks like, oh, well, when my bank account is positive, I have $100 and I add 100 to it, it's now $200. It's not $0. Only if you go negative in your account, negative $100, and you pay $100 towards it, can you bring it to 0. So the character doesn't make sense. How can you bring something to 0 that's already positive by adding to it, right? Any services rendered or compensation which may be lawfully received by any debt collector or the collection of a debt. We still got people jumping in right now. People coming in a little bit late. Number 3, the false representation or implication that any individual is an attorney or that any communication is from an attorney. That's saying that a debt collector cannot be an attorney cannot be a debt collector. It is false and misleading to use one, to present yourself as one as well. So pay attention, because you're going to see with this later when we get to G and when we get to I, why they can't even be attorneys. And since they can't be attorneys, all the things that they cannot do. The representation or implication that non-payment of any debt will result in the arrest or imprisonment of any person, or the seizure, the garnishment, attachment, or sale of any property or wages of any person unless such action is lawful and the debt collector or creditor intends to take such action. So pay attention right here to this word lawful. When you see lawful, that's for us, the natural people. When you see the word legal, that's for the corporations. But it says right here that it is considered fraudulent to say that not paying a debt will result in the seizure of your property. In other words, in the repossession of your property or being arrested or imprisoned. How many people do you know that are in prison or have gone to jail for not paying a debt, right? For not paying tickets, and they stack up and now they got a warrant and they lost time with their family. They had to go away because of unpaid debts. But federal law says that that's not supposed to happen. We've been lied to. Number 5, the threat to take any action that cannot legally be taken or that is not intended to be taken. So yet again, they're telling you it's fraudulent to say that they're going to take any action that cannot legally be taken. They legally can't do anything. The false representation or implication that a sale, referral, or other transfer of any interest in a debt shall cause the consumer to lose any claim or defense to payment of the debt or become subject to any practice that's prohibited by this chapter. It is false and misleading for them to say that because of the sale of a debt to somebody else that you become subject to any practice that is prohibited. Prohibited means not allowed. Number 7, the false representation or implication that the consumer committed any crime or other conduct in order to disgrace the consumer. So number 7 is saying that it's actually fraudulent for someone to indicate or implicate that me as the consumer, the natural person, committed any crime. 8, communicating or threatening to communicate to any person credit information which is known or which should be known to be false, including the failure to communicate that a disputed debt is disputed. So communicating or threatening to communicate to any person credit information which is known to be false, and it should be false, because how can they say that you owe anything when it came from a credit transaction and you don't actually owe it? That's why just by even reporting, period, they're already using your credit report to coerce payment from you as well. On number 9, okay. Let me turn on my brightness real quick. There we go. The use or distribution of any written communication which simulates or is falsely represented to be a document authorized, issued, or approved by any court, official, or agency of the United States or any state, or which creates the false impression as to its source, its authorization, or its approval. The use of any false representation or deceptive means to collect or attempt to collect any debt, or to obtain information concerning a consumer. Everything they do is false and deceptive. That is always a violation. Just by saying you owe is a violation. So anytime they use a form, and I'm gonna get into that on J, it's a deceptive form, and they're using deceptive means to collect. The failure to disclose in the initial written communication with the consumer, and in addition, if the initial communication with the consumer is oral, and that initial oral communication that the debt collector is attempting to collect the debt, and that any information obtained will be used for that purpose. And the failure to disclose in subsequent communications that the communication is from a debt collector, except that this paragraph shall not apply to a formal pleading made in connection with the legal action. So from the very beginning, the initial communication, they have to tell you that all the information they're gathering is strictly for the debt collection purposes. But when you're sitting down with them, you're doing a credit transaction. And that is why they're not telling you any of this, because it was actually a credit transaction that they converted into a loan application. But loan isn't even defined here. 12, the false representation or implication that accounts have been turned over to innocent purchasers for value. So this is when somebody goes for your car, if it got repossessed and somebody buys it, that's an innocent purchaser. That's false and misleading. They shouldn't be doing that. It's similar to a real life situation would be the innocent purchaser would be if somebody stole your TV out of your house and that person sells it to someone in the neighborhood. That person who bought it in the neighborhood is an innocent purchaser. They did not know that it was stolen from you. They may have just thought person's down on their luck and they just need to get rid of some things. The false representation or implication that documents are legal process, that's considered fraudulent because they can't be attorneys. If they can't be attorneys, then there is no legal process for them. So documents cannot be part of a legal process. The use of any business, company, or organization name other than the true name of the debt collector's business, company, or organization. So how many companies do you know that have, like, I don't even know how many DBAs they have. That's a violation as well, because you'll have one company you're dealing with and it turns out that's just a DBA for another DBA that's part of a parent company. So that's a violation to be using these DBAs. That means doing business as, just in case somebody doesn't know what DBA means, it means doing business as. The false representation or implication that documents are not legal process forms or do not require action by the consumer. So you even get some from them where they are legal process, even though it can't be, right? But they tell you, oh no, you don't need to show up. No actions required from you. That's also a violation, because what they're gonna try to do is try to get a judgment on you when you don't show up. So always show up, always take action, never stay silent. The false representation or implication that a debt collector operates or is employed by a consumer reporting agency as defined by 1681 AF. So they can't say that they work for a reporting agency like Equifax and them, which I haven't seen that, but if they were to try it, that's a violation as well. So now we're on 1692F, unfair practices. Now we can go, I'm gonna give you guys exactly what you need, and you need to come back and study as well. And I'm just going to read the first sentence of this. There's more in here, but I want you to pay attention to the first one. A debt collector may not use unfair or unconscionable means to collect or attempt to collect any debt without limiting the general application of the foregoing. The following conduct, the following behavior, the following actions are a violation of this section, which is look at number 1. The collection of any amount, including any interest, fee, charge, or expense incidental to the principal obligation, unless such amount is expressly authorized by the agreement creating the debt or permitted by law. The collection of any amount is considered an unfair practice. Now we're on G, validation of debts. This is another one that I see a lot of people selling templates for and a lot of people buying templates for it, when the law is really all you need. A second. Before I jump right now into G, if you guys are liking what's going on, man, let me see some diamonds in the chat. Let me see some fire emojis, because this is where I'm about to drop some real gems on you right here. This from here, I'm going to jump into truth and lending and show you a little something right here that a lot of people are confused on. Hey, I see someone typed diamonds. That's what's up. All right. Yeah, I see them. Let's go. Let me close this up real quick. All right. Validation of debts. Okay. Right here, there's already a lot of game right here, and a lot of people overlook it, right? Within 5 days after the initial communication, so the very first communication with the consumer in connection with the collection of any debt, a debt collector shall, a debt collector must, they have to, unless the following information is contained in the initial communication, or the consumer has paid the debt, or the consumer has paid the debt. Send the consumer a written notice containing. So within 5 days, they have to send you this information unless the consumer has paid the debt. So, for example, when you guys go into a dealership, you get a car, you sign your retail installment contract. Within 5 days, they are supposed to send you what I'm about to read, unless you already paid the debt. Now, I don't know about you guys, but I have never gotten this notice 5 days after. It's usually a month in, you get your bill, right? 2 weeks later, never within 5 days, but they have to do that by law unless you already paid the debt. So what is it saying to you right here? Number 1, the amount of the debt. Number 2, the name of the creditor to whom the debt is owed. Number 3, a statement that unless the consumer within 30 days after receipt of the notice disputes the validity of the debt or any portion thereof, the debt will be assumed. Remember that word again, assumed to be valid by the debt collector. So they can only assume that it's valid, but only the natural person, only the consumer can say if it is valid or not. Number 4, a statement that if the consumer notifies the debt collector in writing within the 30-day period that the debt or any portion thereof is disputed, the debt collector will obtain verification of the debt. So verification can only be done on an affidavit under penalty of perjury. So they have to provide you with an affidavit swearing under penalty of perjury that you actually owe that debt, or a copy of a judgment against the consumer. But how can they get a judgment if they can't be an attorney and they don't have a legal process? They couldn't get a judgment. And if they did, it's unlawful. And a copy of such verification or judgment will be mailed to the consumer by the debt collector. And a statement that upon the consumer's written request within the 30-day period, the debt collector will provide the consumer with the name and address of the original creditor, if different from the current creditor. So that's what you hear us say, we're the original creditor. They will not provide you with the name and address of yourself. Why would they do that? Right away, it's giving away all their ability to even attempt to collect from you. So from there, let me read GB first. We'll get through the bottom, and then I'm going to take you into truth in lending. Disputed debts. If the consumer notifies the debt collector in writing, again, it's telling them you have to do it in writing within the 30-day period described in subsection A, that the debt or any portion thereof is disputed, or that the consumer requests the name and address of the original creditor, the debt collector shall, the debt collector must, the debt collector has to cease collection of the debt. That means they cannot collect on it anymore, or any disputed portion thereof, until the debt collector obtains that verification of the debt, or a copy of a judgment, or the name and address of the original creditor. And a copy of such verification or judgment or name and address of the original creditor is mailed to the consumer by the debt collector. Collection activities and communications that do not otherwise violate this subchapter, may continue during the 30-day period referred to in subsection A, unless the consumer has notified the debt collector in writing. Again, it's telling you multiple times in writing that the debt or any portion of the debt is disputed, or that the consumer requests the name and address of the original creditor. Any collection activities and communication during the 30-day period may not overshadow or be inconsistent with the disclosure of the consumer's right to dispute the debt or request the name and address of the original creditor. So this is what we talk about when we say notice of dispute. You title it notice of dispute, and you're using 15 USC 1692 GB to let them know you are disputing it in writing, and that you are requesting the name and address of the original creditor, the verification of the debt, or a judgment. And until they give you those things, they have to cease collection of the debt. C, admission of liability. So a lot of people, I know they're going through like, oh, what do I do if I've been paying it already though, or I paid it off? How can I dispute it? Well, look at right here. It says the failure of a consumer to dispute the validity of a debt under this section may not be construed, so may not be taken by any court as an admission of liability by the consumer. So if a court cannot take that as an admission of liability, how can these debt collectors who have no rights and no power say that you're liable for it? A communication in the form of a formal pleading in civil action shall not be treated as an initial communication for purposes of subsection A. So your initial communication cannot be that you're being sued. That does not count as an initial communication. That's a violation of federal law. So let's get to the bottom. The sending or delivery of any form or notice which does not relate to the collection of a debt and is expressly required by Title 26 of the Graham-Leach-Bailey Act, or any provision of federal or state law relating to notice of data security breach or privacy, or any regulation prescribed under any such provision of law, shall not be treated as an initial communication in connection with the collection of any debt. And now I'm going to take you guys into truth in lending, because like I've said in the past, there's been a lot of people trying to say, how can you be a creditor and use consumer protection laws? That they're trying to say, because we're consumers, we can't be creditors. That means we can't be original creditors. So my goal right now is to give you guys clarity on that and shut that down. So here we go. Bear with me. It's going to take several definitions I'm going to go through to give you this. And that is why a lot of people, they don't have understanding of several sections, because that's what it takes to understand your true power. They're not going to give it to you in one simple sentence and break it down for you. We got to break it down for ourselves, but I'm about to do my best right now to give you clarity on that. Let's go. Excuse me. So this is 1602. This is the definition section of the Truth in Lending Act. So we're going to first go to 1602E. The term person means a natural person or an organization. We have the power to choose, but we can be an organization and we can be a natural person, but the organization can never be us. They can only pretend to be. Man, my throat is really bugging me right now. 1602F. The term credit means the right granted by a creditor to a debtor to defer payment of debt or to incur debt and defer its payment. So it's a right that is granted by a creditor. And we're going to get into, from there, my bad. I'm going to go to credit card and I'm going to come back up. So credit card is L. Let's go down. Pay attention. I'm going to try to slow down right here because I know sometimes I just start running with this. I'm going to try to slow up in this section right here. So the term credit card means any card, any plate, coupon book, or other credit device existing for the purpose of obtaining money, property, labor, or services on credit. So any card, but what's the only card that they ask for whenever you attempt to initiate a credit transaction? That's your social security card. So by definition, your social security card is the true credit card. And I'm going to show you why they ask for that credit card. We're going to get into J right here, open-end credit plan. This, when you hear a lot of people talking about all those crazy processes you have to go through to get access to a trust, but they can't explain it further than that it has billions of dollars in it. This is it in Truth in Lending Act. It is an open-end credit plan. So open-end consumer credit plan and an open-end credit plan are one and the same. It means a plan under which the creditor, the natural person creditor, reasonably contemplates repeated transactions, which prescribes the terms of such transactions and which provides for a finance charge, which may be computed from time to time on an outstanding unpaid balance. A credit plan or open-end credit plan, which is an open-end credit plan or open-end consumer credit plan, within the given meaning of the preceding sentence, is an open-end credit plan or open-end consumer credit plan, even if credit information is verified from time to time. Now, your credit card is your social security card. They ask you for that in a credit transaction because that account number gives them access to the open-end credit plan for which they charge you a finance charge on, which is the sum of all charges. But now, after doing all that, we are finally going to go to creditor, which is 1602G. So the term creditor refers only to a person, a natural person who both regularly extends, whether in connection with loans, sales of property or services or otherwise, consumer credit, which is payable by agreement in more than 4 installments or for which the payment of a finance charge is or may be required. Look at this one too, is number 2 is the person to whom debt arising from the consumer credit transaction is initially payable on the evidence of indebtedness and such evidence or by agreement, notwithstanding the preceding sentence. In the case of an open-end credit plan involving a credit card, the card issuer, which could be the corporation, and any person who honors the credit card and offers a discount, which is a finance charge, are creditors. So the corporation who honors the social security number and offers a discount, which is a finance charge, are creditors as well. But who gave them the right, who granted them the right to become a creditor? The natural person who regularly extends. The natural person who regularly extends is the person that made them a creditor as well. That's why when you ask for the original creditor, it's going to be your name and address. Now we're going to go back to G where we were. How'd you guys like that breakdown of a creditor right there? I'm from 1692G. That's to show you as a consumer, we are the natural person. A person under Truth in Lending is a natural person. The creditor is also a natural person. So by being a natural person, you wear so many hats, you have so much power. Like I said, by saying that you can't do that, it doesn't make sense. Says I'm spitting fire, that's why my throat's acting up. Probably. Nobody wants you guys to get this information, but I'm pushing through and giving it anyway. Okay, so we finished G, and now we're gonna go to H. And this one's a short one. Ah, damn it, skip. There it is. Multiple debts. So I don't know if a lot of you have heard about 1692H. And I'm gonna read it right now. So if any consumer owes multiple debts and makes any single payment to any debt without limitation to what the debt collector is, with respect to such debts, such debt collector may not apply such payment to any debt which is disputed by the consumer, and where applicable, shall, has to, must apply such payment in accordance with the consumer's directions. This is the law that everyone hears when they say, oh, how do I get my payments back? 1692H is how you get your payments back. But you see, everything in the law happens in a very specific order, because you see right here that it says, if any debt is disputed by the consumer. So first you have to dispute it. That's 1692G, and that's why G comes before H, and that's why they did that in G. So when you get to H, now that it is disputed, if you cannot provide me with verification and the name and address of the original creditor or a judgment today, that means you couldn't do it the first day when I've been paying you. So by my directions, I need all my money back pursuant to 15 USC 1692H. I hope you guys got that. It needs to be disputed. Once it is disputed, if they cannot provide the information that you requested, that means that they could never verify the debt, not even from day one. So you need that money back. And 1692I, legal actions by debt collectors. Any debt collector who brings any legal action on a debt against any consumer shall, must, right? But let's get down to the bottom of it, because there are all these other things that even says, well, let me see, in the case of action enforced interest on real property obligation, they can bring such action only in a judicial district or similar legal entity in which such real property is located. Or number two, in the case of an action not described in paragraph 1, they must bring such action only in the judicial district or similar legal entity in which such consumers sign the contract sued upon. They can't even sue you without your permission. Now let's get down to this bottom one though. Nothing in this subchapter shall be construed, so shall be taken to authorize the bringing of legal actions by debt collectors. So 1692I is telling you that nothing in this whole entire act should be taken as allowing legal action against you from a debt collector. 1692E tells you that they can't be an attorney. They can't tell you that anything is brought by an attorney. 1692G tells you that even a court can't say that you're liable to a debt. And it says that even if it's on a judgment, it is still alleged. They can't do nothing. They really can't. Furnishing certain deceptive forms. So you have to know that a form is just a piece of paper, a blank sheet of paper. So anything that's put onto any form can be deceptive. Now, this is also, if you have some people, creditors who try to say they're not debt collectors, even though they're collecting the debt. This is how you get them as well. So it is unlawful to design, compile, and furnish any form, knowing that such form would be used to create the false belief in a consumer that a person other than the creditor of such consumer is participating in the collection of or in an attempt to collect a debt such consumer allegedly owes such creditor, when in fact such person is not so participating. Remember that a creditor is you as well. B, any person who violates this section shall be, must be, will be held liable to the same extent and in the same manner as a debt collector is liable under 1692K for failure to comply with the provision of this subchapter. So even if they say that they're not a debt collector, well, you created a deceptive form, and pursuant to 15 USC 1692JB, you shall be held liable to the same extent as a debt collector under 1692K. And that's where our money is in 1692K. And that's what we're about to get into. Civil liability. Now, I was on a live, I don't know if it was in the Facebook group or on Instagram. I was on a live with Sophia, and we broke that down because I don't know why there's people out there that really think that these debt collectors can just run rampant, do whatever the hell they want to you. and take all kinds of stuff from you and damage you so severely, and all you can charge them is $1,000. That's what people are really out here thinking. Well, I'm about to show you that that's wrong. Amount of damages, except as otherwise provided by this section. Any debt collector who fails to comply with any provision of this subchapter with respect to any person is liable to such person in an amount equal to the sum of, number one, any actual damage sustained by such person as a result of such failure. Any actual damage, there's no limitation to that. Anything that you can prove. So the collection of that debt led to you having to work so much overtime that you were never home. You and your spouse started getting into fights. Now you're so stressed out. You're seeing a therapist because you don't know what's going on with your relationship. How much damage did it cause you? Any actual damages is what you can charge them as long as you could prove it. Now 2A, this is the part that people are getting confused on. In the case of any action by an individual, such additional damages as the court may allow, but not exceeding $1,000. So people read this and try to say, oh, well, see, all it needs is just one case. You only get $1,000. No, any action, an action is just something that is done by an individual or one single thing. It doesn't say actions. Had it said actions, then it would be, okay, they can do a series of actions and only get charged $1,000, but no. In the case of any single action by an individual, $1,000. An action can be a word. An action can be just one single thing by an individual, by these agents. If you want it to be petty, and I wouldn't say petty, but an action is a word. How many words did they write on your letter, right? How many times did they deliberately violate you after you put them on notice that it was a violation? That's $1,000 per violation. This one is saying just in the case of a class action, the amount of each plaintiff could be received is, class members regard to a minimum individual recovery to not exceed lesser of $500,000 or 1% of the net worth of the debt collector. That's the class action lawsuits, right? But when there's a class action lawsuit, the only people who get that money like that is the people who brought the class action lawsuit, not the people who join it. If you join it, you're probably gonna get a damn quarter or something. Only the people who brought the action get that type of money. So in the case of any successful action to enforce the foregoing liability, so they're telling you it is our job to enforce this, right? The cost of the action, so you can charge them the cost of the action together with reasonable attorney's fees as determined by the court. So reasonable attorney fees, they vary, right? Because you can hit up an attorney that'll do it pro bono, and then you have an attorney that charges $500 an hour. So you contact an attorney, you get their information. Hey, how much would you charge me to take this type of action, right? What's their rate? That sounds like a reasonable attorney fee. Now, how many hours did you spend on it if you're doing it pro se? That's what you could charge them. I'm trying to see right here, jurisdiction. So a debt collector may not be held liable in any action that's brought under this subchapter if the debt collector shows by preponderance of evidence that the violation was not intentional and resulted from a bona fide error, notwithstanding the maintenance of procedures reasonably adapted to avoid any such error. The only way a debt collector cannot be held liable is if they can prove that it's a bona fide error, meaning a one like this just happened to only you. This is an accident. But once you put them on notice that they were violating you, they intentionally continue to send those letters, and they do the same thing to everyone else. There is no way that that's a bona fide error. They will try to use that defense, but they have to prove it. From here, we're going to go to 1692N, relation to state laws. So if you've heard me speak a few times that I went live already in the Facebook group or on the Instagram, I always mention that the law is always in our favor. When you know who you are, the law is always in your favor. So right here, it says this subchapter does not annul, alter, or affect or exempt any person subject to the provisions of this subchapter from complying with the laws of any state with respect to debt collection practices, except to the extent that those laws are inconsistent with any provision of this subchapter, and then only to the extent of the inconsistency. For the purposes of this section, a state law is not inconsistent with this subchapter if the protection such law affords any consumer is greater than the protection provided by this subchapter. So federal law supersedes state law at all times unless state law gives you greater protection. It is literally saying that the law is in your favor. The only time that state law supersedes it is if it gives you even more protection. So that concludes the FDCPA portion. Now I'm going to show you an example debt collection letter that most of us have seen, and how to find the violations, how to highlight them, and how we would use an affidavit to back that up. So give me a second to get to the the right screen on my laptop. Give me 1 second. How you guys liking the class so far? Drop some I love myself in the chat. You guys liking this? Drop some diamonds, some flames. Let me see something. So I know a lot of people, they get these letters and then they say like, well, I know they violate me, but I don't know how to do it. I don't know how to violate. I don't know how to highlight it. I don't know how to show it. So here's an example debt collection letter. And there's 2 different ways that I did it. Now, these are not the only ways to do it, right? You could use a highlighter. You can use a highlighter, a different colored pen. You can just underline things. So I'm going to get into it. I'm going to read the letter to you guys. I know a lot of you have seen letters like this, right? Let me zoom in a bit so I can actually read it. So this letter is from Snake Collection Service at 123 Gotcha Lane, Tricked Again, California, to John Doe at 1990 Consumer Ave, Natural Person, California. So the original creditor is saying is Sprint. Here's the reference number. They're saying the total amount due is $2,476. Dear John Doe, this letter is to advise you that your account referenced above is delinquent and has been placed for recovery with our office. Please forward the full balance you owe with a copy of this notice to ensure proper credit, or call our office at 800-555, Alternatively, you may access your online system to pay your balance. We are willing to settle this debt for $375. Be advised that failure to pay this debt will result in it being furnished on one or more of the 3 major credit bureaus, and you possibly being sued by our office. You have 30 days to dispute the validity of this debt. Failure to dispute the validity will result in our office assuming this debt to be valid. A consumer has the right to request in writing that a debt collector or collection agency cease further communication with the consumer. A written request to cease communication will not prohibit the debt collector or collection agency from taking any action authorized by law to collect the debt. This is an attempt to collect a debt. Any information obtained will be used for that purpose. This communication was sent by a debt collector from a professional debt collection company. And then once again, at the bottom, your name, their address, total amount due, and their logo. So there's 2 different ways that I've used in the past. I've used both of these ways. Excuse me. I've used both of these ways to highlight the violation. So of course you have to circle it or let them know. So see, this one is a lot cleaner. It just has a 1, a 2, a 3, a 4, 5, 6, and 7. This other one I actually wrote, this is a violation of 15 USC 1692 B5. I put 1692 Jakes. This is a deceptive form. This is a violation of 1692. I can't even see what that is. I believe it's B2. Yeah, because it's saying you owe. And keep in mind, I did not highlight every single violation in this letter. There's still a lot more that you can find. So I put it on here, right? You highlighting these, have these violations. It's market. I'm over here pointing like you guys can see. Market Exhibit A. And if you have multiples, then you go Exhibit A, B, C, D. You just go down the line, right? And then you have your affidavit of truth. I like to title mine Affidavit of Fact, only because all of this is a word game. This is all word games. So when you say somebody tells you, you know how many people you've seen telling lies left and right, and you finally call them out and they say, well, that's my truth, knowing they're full of you know what. So truth is contrary to the person, but a fact is a fact. And that's why I title mine Affidavit of Fact. Now, let me get to that. I was still typing it up, so I typed this up for you guys just today, right before class. Now, these documents that I'm showing you, they'll be in the portal as well. I'm going to send them, make sure they get added in so you guys can look at them for examples. Okay, so like I said, your affidavit backs up your exhibits back up your affidavit. They go hand in hand, they work together. So this is just an example one, right? You have to title it, title everything you send. So this is affidavit of fact. Notice to all, I am that I am the consumer in fact, natural person, creditor, lender, executor, administrator, holder in due course of any and all derivatives thereof for the surname / given name, John Doe, and have been appointed and accept being the executor, both public and private, for all matter proceeding. And I hereby claim that I will do business as John Doe and autograph as the agent attorney in fact. So be it. We are attorneys in fact, because we're the only ones who know the facts of the transaction. And that's the first thing you do. Your whole job is to state who are you, and then who are they, and then what's going on. It is a fact that the affiant, which is just me, the person that's on the affidavit, is the only natural person with firsthand competent knowledge of the facts of this transaction. Number two, it is a fact that affiant is a consumer as defined in the Fair Debt Collection Practices Act, specifically 15 U.S.C. 1692A3, because the affiant is a natural person. That's just the definition of a consumer. It is a fact that Snake Collection Service is a debt collector as defined in the Fair Debt Collection Practices Act, specifically 15 U.S.C. 1692A6, because they are attempting to collect an alleged debt. So I already said who I am in the transaction, who they are in the transaction, and now we're getting to the violations. But in all the time in your affidavit, you were stating facts, no emotion, strictly facts. It doesn't have to be super long facts. Each one, it could be very simplified language, but just get to the point and be specific. Where was I at? Number 4. It is a fact that Snake Collection Service is in violation of 15 U.S.C. 1692B5 for using their logo, indicating that they are in the debt collection business. So I put C Exhibit A. Or if you remember how I wrote numbers next to each one that I circled, so if I was doing it the way with the numbers that are circled, I would say C Exhibit A1 and A7. So Exhibit A and then number 1, number 7. They know specifically where to look. 5, it is a fact that Snake Collection Service is in violation of 1692B2 for stating that affiant owes an alleged debt. See Exhibit A or see Exhibit A2, A5, and A6 because they said it multiple times. It is a fact that Snake Collection Service is in violation of 1692E2A for using a false and deceptive character for the alleged amount due. So you can see Exhibit A or A3. It is a fact that Snake Collection Service is in violation of 15 U.S.C. 1692 D1 for threatening to harm my personal reputation over an alleged debt. This is where they said that, oh, if you don't pay, we'll report it to the bureaus, right? They're threatening to ruin your reputation. It is a fact that Snake Collection Service is in violation of 15 U.S.C. 1692 JA for intentionally furnishing a deceptive form. See Exhibit A, because that's the whole page. You don't have to be specific. It is a fact that Snake Collection Service is in violation of 15 U.S.C. 1692B4 for communicating with affiant by postcard without the express direct permission of the affiant. See Exhibit A. And just another statement at the bottom. What the hell? Just a statement at the bottom that says, I swear to all information provided herein, I do so under the penalty of perjury that the information I so affirm to be true, correct, and accurate, and to the best of my knowledge, so be it. I do not accept this offer to contract. I do not consent to the proceedings. print your name, signature, sign on the date. But obviously you would not sign this without a notary. So you would sign this in front of a notary, but you would have it prepared right there for when you have your notary come and you sign it in front of them. So the reason it says do not consent to contract is because every time we send them a debt collect, not a debt collection, every time we send a letter as well, right? It's a self-executing contract. It could be looked at as such because you are saying, I am requesting this information. If this information is not provided, these actions will be taken. It's a self-executing one because you are saying this is what will happen. The same thing they're doing. They're sending you a self-executing contract by saying, here is the debt that you owe. If you do not respond in X amount of days or dispute it or don't pay it, these things will happen. So that's why I do not consent. I do not accept this offer to contract. And then, of course, we have resources. And let me get back to, there it is. So we have different resources to use. They mentioned the CFPB, right? So I'm just gonna go there so you guys can see what that looks like. And this is in my way. Let's see. So you would go here, click on submit a complaint. And they have a bunch of articles you can read as well and get education on. I like using Law Doc Cornell, which you guys just see me reading through. It's just easier to navigate. And keep in mind, when I was going through those definitions, if it is not in blue, it's not for you. If you can't click on it and get the definition, then don't worry about that term. That's on Law Doc Cornell. So you click on start a new complaint. So you have to put in all your information, right? And as you go through this, it asks you, have you tried to work this out with the company? So before me personally, before I send a CFPB complaint, I already did my debt validation letter. You know, I have the violations highlighted as I shown you. I have my affidavit. I'd send that certified mail, which just means with tracking with the green return receipt. So the green return receipt means that they have to sign for it, and then that gets sent back to you. So now you have physical proof that it was signed for. So I'll send a letter, boom. I'll wait for them to sign for it. I get my green return receipt back. I scan that in with everything else that I scanned in, because I keep copies of everything, which you should do, keep copies of everything. I initiate my CFPB complaint. So that way, when it says, have you tried to work this out with the company? I click yes. It doesn't matter that they got the letter 2 days ago. It doesn't matter if they got it today. The fact is I did my part. They have the letter and I have confirmation and proof that they got it. You also have the Attorney General of your state or the state that they do business in. I personally, I do the complaint through my state and their state that they do business in. That's not something you have to do. That's just more in my eyes to put more fire under their ass. They're getting hit from all sides, right? And then we use, of course, we showed you the violations. We know that it's 1,000 per. So now this is just one I use, invoice generator, right? So you would put today's date or whatever date it is that you're writing it, your payment terms, just say, you could say pay by check, want to say pay by check. You can say that it's due on whatever day you want to say, let's say Friday, next Friday, right? You put bill to, you put their number, their address, their information. Who is it from? You put your name. It's really that simple. The rate per violation is $1,000. So you would say for violation of 15, USC 1692 B2. This is the law that says they can't say you owe anything. Now, how many times did they say it on our letter? They said it about 3 times. So times 3, it's $1,000. Now you would just keep going down, adding your violations. So your affidavit shows and explains the violations. Your exhibits are right there to back up your affidavit. And then your invoice is there to back up the violation. So, okay, we did this and that. This is the violations you have. There's the proof of it. Here's the invoice that goes along with the proof. And then in your debt validation letter or your notice of dispute, you're going to include, when you include this, you tell them to pay. The part of your remedy is what? Pay the invoice for the violations. You don't just send the invoice without instruction for them to pay it. Now, I know that we understand that you have to pay an invoice, but they are always going to intentionally misinterpret what you say and misunderstand you. So be as direct as you possibly can. Now, if it's a bank, you can also use the OCC. If it's a credit union, you can use the NCUA. And if you don't know who regulates the company you're going at, you would literally go into Google and type in who regulates, like say Verizon, right? Now, the person you send it to, there literally says on the back of your letter, you can send it to that spot as well. Now, if you want to send it to a registered agent, which is just another person, or even sometimes another company, this is how you would do it. This is how I do it, I should say. There's other ways to do it. I will go to D&B, which is Dun & Bradstreet. So a lot of them, they have all their information's in here, right? And now, let's say if we're looking for CarMax, I'll type in, I don't want CarMax. Answer. Scroll down, let's see. So I look for the parent. This time it just so happens that the parent company is the first company it shows, but usually you have to go through, look at that, all 651. So you have to scroll through and try to find it. So, okay, we found the parent. Let's see, where are they based at? But you see how many different names there was, how many DBAs they have. That's how it makes it so difficult to find them. So I rather just find the parent. Let me go to the root, which is your parent that birthed you, right? And I'm going to go to them and tell on their child, their subsidiary, what's going on. So let's see right here. Boom, there is the address, right? And this is where the CFO is. It's where everyone's at. But I want to pay attention to that. What state is it in? VA, right? Which is Virginia. So I would type in Virginia Secretary of State Business Search. Boom. Wait for that to load. Starts with entity name. I'm gonna put CarMax. Why does it keep trying to say CarMax? CarMax Inc. Let's just search. There it is. There's the address. It matches what we've seen on D&B. Entity ID. Registered agent information. Their address, their name. So once you hit the point, if you're going to go to the big boy step, once you've done your due diligence, I send it. If I'm going to do a intent to sue, I send it to the registered agent. And I'll send it like next day express mail, costs like $26 to send. So it shows this is an important document, So that was the FDCPA with a little bit of truth in lending, just to show who we really are in these transactions. I went over the CFPB. I showed you an example debt collection letter. I showed you how an affidavit should look and should be structured. Showed you what you're going to do with your invoice, who you would send it to. Let's see how you guys liking it so far. Now I could look at the chat. Now I see it. You guys feeling good? Let me get some I love myself. Let me get some diamonds. Let me get some flames in the chat. Oh, no, Sophia, what's up?
No, you're good. You're good.
I see you pop up. I was like, uh-oh. No.
I just came on to say, I thought I told y'all. I thought I told, I'm not sure, but I thought I told y'all I was going to be fired. Like, I don't know. So if you're ready, Jesse, we'll do question and answer. And how we'll do this is you have one question each. Okay. We have 84 people in this class. It is important that you wait for me to unmute you. Okay. And then you're going to ask your one question. And then, yeah, we're going to keep it rolling like that. I got my moderators in the background. They're going to be helping me out. And if you're ready, we'll get started.
If I'm ready.
Yeah.
Let's
go. All right. The first one is going to be Will Matai.
Okay.
I just sent you a request to unmute. Okay, you can go ahead and ask your question.
Hey, I was trying to figure out, like when you send a cease and desist and they try to play games as far as like, not responding because you said don't respond if, don't respond unless you're telling me that you're removing it off my account. what's the best way to do that? Are you sending another cease and desist or saying, okay, well, send me these documents, or are you just proceeding in the administrative process, which is the notice of default? And then when you do send these notice of defaults, are you sending new affidavits with that as well?
So on your cease and desist, you can tell them too that they need to respond to you just to let you know that they received it. You could say that as part of it. Now, with your affidavit, you would only send a new affidavit if they gave you new information, new exhibits, right? You wouldn't just always send and make a new affidavit every single time. It would only be if you got new evidence, because now you need something to show and you need to back up those exhibits, those new ones that you got. Does that make sense?
Yeah, it makes sense, but I already sent in my cease and desist, so I'm trying to figure out how
No,
to
we're not doing follow. We ain't doing follow up. Just one question. Sorry, I gotta interrupt you. So, we're not gonna be able to get. And I'm not trying to be rude, y'all. I promise you, I'm not. But we got 84 people. We gotta be fair, okay? So, Jesse just gonna answer. We're not gonna be able to get to everybody's, complete understanding. But let's get through the question and answer. And somebody else's question might help you have better clarity, okay? Kalisha Griffin.
All I can say real quick is just keep pushing, continue to go. When you send your next one, send your cease and desist again and say, hey, just to reiterate, because you must be confused, right? Treat them like children because they are. My bad. Go ahead, Sophia.
Oh, no, you're good. Kalisha, you can go ahead with your question.
Thank you. Hey, Jesse. So I disputed originally with the credit reporting agencies and not directly to the actual original creditor. I know, like, I'm the original creditor, but so what happened was the debt collection company actually sent a letter saying, hey, we got your dispute. So my question is, following this process, do I still need to send them a letter basically stating I'm disputing this account, please send me validation of debt of this account? Or because they basically, like, they stated that they noted that this was disputed on the account. Does that make sense?
Yeah, so they know it's disputed, but I don't know what you said to the credit reporting agency, right? So go at them and be, okay, it's disputed. Depending on what you requested from the credit reporting agency would matter on what you're going to say next to the debt collector. So if you didn't ask for those things that you just mentioned, the validation, verification, demand it from them now. And as part of your remedy, as you're dealing with the debt collector, you want the account removed, or you want the account showed as paid in full, whatever your remedy is. But now go after them. They know it's disputed, so remove it.
All right. Next we have Joaria.
Hi, this is Joaria. I have a question about 1692G.
Okay.
A, where it says within 5 days after initial communication with the consumer in connection with a collection of any debt. So you're saying within 5 days of them sending me my first statement?
No, within 5 days of the initial communication, right? So they're trying to say that you got a loan the day, just say, let's use the example of the day you got a car from a car lot. They're trying to say that that day you got a loan for that car. So within 5 days after that day, they have to send you all that whole list of 1 through 5, unless the consumer already paid the debt. And why don't you get it in 5 days? Is it because you already paid the debt when you entered into that credit transaction?
No, I was just trying to understand what was the first communication of collecting a debt. So when they give you that agreement or whatever it is.
Yeah. You're sitting down with them, putting out that agreement, because that's when you supposedly got a loan, right? And they're saying you got a loan, so they have to give you all of those things, but they don't.
Okay, Letitia Dunning.
Hi, my name's Letitia Dunning, and can you hear me? I'm sorry.
I got you.
Okay, my husband has a situation. He lost his job, and his car came from the credit union. He relapsed on his insurance, and the credit union won't work with him. They put forced insurance on his car note, which put it from $398 and jacked it up to $827. My husband is behind. This will be the third payment on the 27th. And what I want to know is, how do we stop a possible repossession?
The only way to possibly stop a repossession would be to put them with a notice of dispute and a cease and desist. And you'd have to mention specifically that the note that a repossession would not, that's something you're trying to cease them from doing in the cease and desist, right? And the fact that they force that on you to enter into and add insurance, there's a finance charge attached to that. So you need that information as well. But the only way to possibly stop it is to put them on notice in writing, as we've seen in law, right? It says that it has to be in writing. So do not do it over the phone. It will not be sufficient. It needs to be in writing.
All right, Tina.
Hi, good evening, great course. I wanted to ask you a question. How do you handle it in reference to receiving the emails from the collector? I mean, from the debt collector.
Mhm.
I know I haven't opened up the email, but I know it's from Mid-Landon because they have sent it to me via mail. But how do you do it? You do it the same way?
Print it out. That's a communication, a form of communication. It says through any medium. Email is a medium. They're still communicating with you. So you just have to print that out and, you know, highlight the violations, and everything else is the same.
Savage Doll, you're next.
I'm sorry. Thank you. So this was my question. So for the 1681 AD2A, the first one, the exclusions, like, can they be used together with the Graham-Leach-Bailey Act? Like, if you go get a loan or whatever, and then, you know, when you get the loan, they basically report it. They report like your late payments to the credit reporting agencies. So are you able to use both of those together, since they never gave you that information as far as like how to opt out of like the disclosures before they actually send out their information? And then with the exclusions, they're not supposed to like basically report transactions,
You can
if that
always,
makes
yeah, you can always combine the laws as long as you can articulate yourself properly enough to explain why you are mentioning the Graham-Leach-Bailey Act and or any other law you may bring in, the FCRA, the FDCPA, combined with the Truth in Lending Act. As long as you can explain the transaction, whether it be through your affidavit or through your original letter, however you do it, you use your affidavit as well to tell a story through facts. So you can use it definitely.
All right, Miss Charlisha Miller.
Hello, so I wanted you to elaborate on 1692E2. As far as if you're trying to use it as far as something like, you were saying like you could use it towards like a car note or something like that. Because I have a client that, and this was on a business side. I do a lot of affiliate stuff. So they were supposed to send an email to them to start making payments for a virtual address. It was Opus, which, you know, some of you are familiar with. And because they never got the email, they never was able to make their, you know, their payments. So now it's like they're calling my phone and they're emailing me. And now, like, I know it's a violation because I never heard from them, but they're sending me emails. And I've told them multiple times that, you know, this was not for my virtual address, this is for a client. And they're contacting me about her information. And now they're trying to basically say like, okay, we're going to take this to court for, you know, or whatever. So I'm just trying to see which way I should go with that.
But you're talking about 1692E2A, where it's talking about the character amount. That was the original code you mentioned. It's talking about the character or the amount of the debt.
Right.
The legal status.
Yeah, that's what she had said.
Yeah. So that amount that they're showing, I'm pretty sure is going to be a positive number. So the character of it is incorrect. And it's a little different when it's with business, because you have to be able to prove that it was for personal, family, or household purposes. And the fact that they're communicating with you, they're violating the communication 1692C and B, because they're supposed to be communicating directly with the person to whom they're trying to get information from, not you.
Right.
Unless
So
anyone
that's what I was thinking, and I told him.
Sorry, we can only do one question. One question. Thank you. Timothy Cooper, it's your turn.
Thank you. Jesse, my question is, okay, so when you're at a dealership, they will run your credit application most times to many companies. What can we do about the multiple hits that we'll get on our credit report or our signature that will be seen utilized through our application? That signature allows for them to go into our trust account, and that's going into many companies. What can we do about those multiple companies that are getting our signature?
Well, that would depend, because that's more under the FCRA, not really the FDCPA in that circumstance. So it depends, what do you want out of them running your credit, because they got compensated. So do you want them to approve you for another car? Do you want them to pay you for the violation? There's different routes that you can take when it comes to that. But they did not have permissible purpose.
Okay, Moni Shipman.
Hello. So my question is, I just recently got a new car and I'm wondering, should I do the debt validation when I get my first car note or wait? Because now the bank is sending me things like my loan coupons. When I didn't go through the bank, I went through the dealership.
Mm-hmm. And that's why on your retail installment contract, you'll see they'll say that it was assigned to, and then that's where it usually has the bank's name. And we've seen what the FDCPA says about a creditor when there's something is assigned to them, that they're not included in the definition of a creditor. But it is up to you. You can do your notice of dispute at any moment. It could be before you get the alleged bill. It could be after you get it. It's at any time that you're ready to do it. But I do not suggest that you just do not pay unless you are ready for the repercussions that could possibly come from not paying.
Okay.
Didi Blaze, it's your turn. Sorry, y'all. I thought I was off mute.
Oh, okay. Hey, everyone. Thank y'all for having this class today.
Of course, thank you for being here.
Oh, thanks. Look, I did my dispute with Capital One for auto loan. Anyways, I sent in validation. Anyways, they sent me a letter back, and they was accelerating like, oh, we're going to basically tell me that I have to pay a certain amount, pay a full amount, pay this whole balance. And basically in the letter, it just says like, oh, well, we either do that, you either pay it or you'll get a car repo, right? So it's just really crazy because it's a positive, like you stated. And how can they even have that in a letter that they're going to accelerate something when I'm just asking for validation?
Mm-hmm. I would say that it's because a lot of consumers are waking up to who we really are and we're enforcing our rights. These companies are getting scared. So that's just, now they're trying to coerce payment from you. They're using harassing you. They're using abusive language. There's a gang of violations. Just from what you're telling me, it's something, there's a lot of violations. That's an exhibit. That's ammo against them. They can't really accelerate, but they can try, right? As long as you don't do anything, they will accelerate it. But they're getting scared, and that's why now they're like, oh, damn, there's too many people waking up. There's too many people asking us questions. We need to shut this down. And that doesn't mean that it's an empty threat. You need to act on it, though. That's evidence. That's ammo against them.
AB.
Hi, how you guys doing? Thank you, Jesse, so much for the class, boss.
Thank you.
I currently have a eviction from I want to say 4 years ago, and they're actually taking action. Like they sent letters in the mail about taking action, and I actually have a court case pending as we speak about the said debt. And I was just asking if I was to just start this whole process, is it too late to start the process, even though I have a pending case coming, or like how would I go about that?
No, it's not too late. You need to put them on notice of something, whether it's rebutting the allegations they have against you or a counterclaim against them, but you need to do something, and you can do something.
Angelus.
Hi, Jesse. Hi, everyone.
Hey.
I guess I'm trying to understand the verification of debt. I'm not sure exactly. I know he said in what you read is a statement or something like that. What is exactly how do I know when they send me something back if it's really verified or not? What should I be receiving that's legally the verification?
So you seen how I showed you the affidavit, and we said a bunch of statements and we stated them as facts, and we did that under penalty of perjury. We swore under penalty of perjury. That's what they need to do as well. Otherwise, it's just hearsay and it can't be validated. They need to send you something verifying under penalty of perjury. So it'd be like, if you ask me, I'm like, yeah, you owe me $1,000. I'll sign a piece of paper saying that under penalty of perjury, I am stating a fact that you actually owe me this money. That's the only way something can be verified.
Also, I was gonna jump in there. What's the code, Jesse, for verification?
For verification, 1692 GB.
All right, because I don't know the codes by heart. That's why he's the. But under that code, there's like 5 things that they have to do under the law as well that constitute verification. If they haven't done all of those things, it hasn't been verified. They don't get the luxury to skip around and be like, well, we did 1 and 3, but you didn't do 1, 2, 3, 4, 5. So if they didn't do the things that Congress said they have to do to verify, it's a wrap. Sorry, I just had to throw that in there.
Nah, you good.
Charles, you're next.
Hey, Duke. My question is, am I on the right path? Okay, so I had a credit card. And I basically used the UCC one to send in my remittance coupon. They closed my account and they sold it to another company. The company sent me a letter and they gave me the right to dispute the debt. I disputed the debt, and I also sent them my own letter using 1693A2 and also 1692CC. They then sent me another letter, but they sent me a copy of the original credit card company's statement. So now I'm in the process. I just sent off my validation of debt. I will be doing I will be marking up their letters and also doing the affidavit with the invoice. I just wanted to make sure that I was taking these steps correctly, if I did that in the right order.
Yeah, you're fine where you're at, but see, when they sent you that too, where's the contract between you and them for them to collect from you? That's something to keep in mind as well. They're the third party, and that does not constitute the validation of debt, either contracts and all that stuff. Umar has the case law. He's mentioning it. I don't know if you know it, Sophia, because I always forget the name of that case law.
It's in the Facebook group.
Yeah, I know. I was just trying to remember. Like, that's the one I can never remember it off the top of my head.
They can go find it. You gotta get them some home. They got to do some stuff on their own. Just do
some homework. But no, man, you're doing well. Stay consistent. Don't let up on them. Truthfully, us as consumers, we only lose once we allow them to keep going because we stop fighting. As long as we keep fighting, there's always the potential for remedy.
Thank you.
Trania, you're next.
Hello.
Hey.
So I'm just starting, like literally this week, starting everything. I want to thank y'all for the class and all the information. My question is, so when we start the process, is it that we send in the cease and desist letter, or do we do the mark up the letters and do the fact of affidavit? or the affidavit of fact, I'm sorry.
Yes. So it's really up to you how you're going to start. Like I said, I start, with a debt validation or a notice of dispute, which is under 1692G. Let them know that I dispute the debt and I'm demanding verification, name and address of the original creditor. That's a way to start. You can send the cease and desist along with that, or you can have the affidavit if they've already sent you letters and you want to mark up violations and have an invoice attached from the jump. There's different ways to go about it. You don't always need to send a cease and desist. Me personally, I don't send a cease and desist unless it's like a third, what we would call a third party debt collector. If it's not a third party debt collector, then part of my remedy is always that they need to continue to do business with me in a sense. So as a natural person as well, we have that power to choose. We can fight however we want, but the main part of it is just speaking up and letting them know that there is a dispute.
Carletta?
Hi, how you doing? I have a question concerning, I've been looking up and down the laws and I had it once, but now I can't find it. I was actually looking for if you could kind of lead me in the right direction on what consumer law that covers fraudulent actions when a dealership coerce you to sign a contract knowingly that you weren't allowed to go into that contract because of the conditions that you spoke about legally that prohibits you from entering into a contract, meaning that I was under narcotics from a heavy surgery, a major surgery. So I had saw it once and now I cannot find it again.
Well, that's going to be for sure in the Truth in Lending Act because they have required disclosures. It needs to be clearly and conspicuously disclosed to you, anything that you sign. So that's why you have to receive adequate notice. So if you didn't receive, you received inadequate notice, right? But you'd have to be able to prove that as well, that you let them know about your condition at the time. But more than likely, you're going to find it in Truth in Lending Act.
iPhone? I should skip you because you don't got your name on there, but I'm being nice today.
There you go. You got lucky. You got lucky.
You did because I sent him, or she did because I sent a message too that said change your name to your name.
How you doing?
Good. How you?
Okay. The only question I was having was how do we just handle it? Peace and light. How do we handle it only when they already did the repossession or already repossessed the home, and it meaning they already, it's already gone. Is there a way to remedy or is it too late?
It's never too late. Maybe it might be too late to get the property. You know what I mean? It might be too late for that portion of it, but you were still wrong. So there's still that opportunity for remedy, whether it be a compensation through, if it's a car, through another car, or just money back as remedy, or even through a house. Maybe it's just money back as remedy and approval on another house. But there's always opportunity for remedy. Probably not getting the property back, though, if it's already sold to another person, to an innocent purchaser, right?
Karina Ramirez, you're next.
Hello. Yes, I have a question. After sending them clear instructions to remove collection from credit reports and pay for the violations, how many attempts can I give them before taking them to court?
Well, you have to do your due diligence. That just means you have to at least give them the opportunity to rebut or send you evidence or abide by what you say. But it's truly up to you. When you feel you have enough exhibits, when you feel you've done your due diligence, and if you feel ready for court, then that's really at your own discretion. But it would also not make sense to go back and forth with them, say, for a year and not take them to court. Or if you threatened it already in one of your letters, that's what I meant by it's a self-executing contract. If you said, I'm requesting these things, if you don't do it by this day, I'm going to pursue litigation, or I'm going to do this. And then that day came and went, then obviously you're making false claims. You're not even going by your own words. So whenever you feel ready that you've done enough with them and have enough rounds, what I call them, then you can go into court if you're ready for that step.
Eric, your turn.
Hey, how y'all doing?
Good, good. How you?
Ugh, tired. I just got off. So I got my wages garnished from student loans a few years ago. Would I send an affidavit of truth or do the administrative process to get that money back?
Well, the administrative process is a name we use for the process that you decide to use, right? So an affidavit of truth, affidavit of fact is just included in those things. But whoever it was that initiated the garnishment or sent the letter for the garnishment, the person who garnished you is also a debt collector. So your job, if it's a previous job, that would mean that they're a debt collector at that point. So you could start with the notice of dispute. And if you have proof of that, then you use that as your exhibit as well to show what it is you were disputing.
I just want to add a little bit of extra flavor to that sauce he just gave you. When you see in the news and in the paper and popular events, when things are changing and you were violated, there's no statute of limitation on fraud. So you can use that for your situation. I'll give an example. I had a guy I was doing a consultation with. He was fired from his job because he refused to get the jab, right? Those healthcare workers that just got that settlement, that those millions of dollars for being fired from their job for not getting the jab, he can use that case law to his advantage for his situation because it was the same thing. So, Melissa, your turn.
Extra sauce on that shit.
Thank you so much for the class, Jesse. And so I just went through my emails and I found close to 80 letters or 80 emails. And those are only the ones I stopped deleting once I learned this information. But that's going to be over 6 figures in violations. I'm assuming they're not going to just roll over and send that to me with my affidavit and invoice. So I'm just wondering what I should expect so that I can be a step ahead.
What you should expect is a fight. And that's why I literally treat my letters, I call them rounds. So when I first send my first, set of letters of disputing and everything, I say round. When I scan it and I put it back in my folder, it's round 1. Then it's round 2, and then it's round 3. And then that's when I hit a point, okay, I'm probably going to sue them. And as however big of the check is that you want is how much you fight for. Because you may hit a point where they offer you a settlement, right? And that's up to you if you want to take it or if you want to push back and counter offer with a little bit more. But realistically, what you can expect is a fight for that ticket. You know what I mean? Don't expect 1 letter, 2 letters is going to get it for you. Keep pushing though. Don't give up. Like I said, you will always get what you ask for, at least a form of remedy, as long as you stay consistent.
Andrew?
Peace. Can everyone hear me?
Yeah.
Someone said they're gonna need a consultation with both of us for Sophia, that they love.
Can you hear me, Duke?
Yeah, I got you. I hear you.
Okay, hey, great job, man. I appreciate the gems and insight. My question is, if you you go to court, you stayed in state court, which is kind of probably learning process here. You get a final judgment. They haven't really provided any kind of documentation because we all know that they really don't have it to provide. So you get a final judgment. I know there's an appeal process, but I was just thinking, is it possibly you could still send outside of court to the actual attorneys, like the administrative process, as you stated, in terms of notice of dispute, affidavit of truth, because now you have all the evidence that was filed in court. You can use those as exhibits in your affidavit of facts.
You could, but I would also appeal it because as of right now, if they have a judgment, it is technically enforceable, right? So you could do that, but also you have to appeal the judgment or else it is enforceable at this moment in time.
You can also file your own lawsuit in federal court.
With evidence.
With all the evidence
Right.
that you have in from whatever they were doing to you. So, I mean, I would definitely appeal if you don't want them to move forward with like a garnishment or something because they do have a judgment. Or you could take the chances that when you file a federal lawsuit against them, that they dismiss it or don't do anything with their judgment because they don't want to rock the boat knowing that you have a case against them. But all things in moderation and as you feel comfortable. So like the other lady, if you have 80 adverse actions in your email, I would not recommend that you do all 80 adverse actions at one time. You're going to be overwhelmed. Remember, this is a paper trail, right? So you're going to have a lot of paperwork. It's going to be a lot to keep up with. And then, you have to respond until you're ready to take the next step action or whatever that may be. So just know your limit and do what you feel like you can reasonably juggle. Tino?
Hello. Thanks so much for the class and for breaking down the FDCPA. I guess my question was actually answered because I was garnished in the past by an attorney so I was just wondering if there's anything that you can do for like a garnishment in the past, but I guess that question was answered. So I just want to say thank you.
Yeah,
no problem. You're welcome.
Tommy?
When you start your dispute process, what's the best way to go about it? Should you go to the credit reporting agencies first or go to the alleged original creditor, whether it's a car lot or a credit card?
Me personally, I go at the person that's furnishing the information to the credit reporting agency. But you could do both. But if you go at the person who's reporting the information, part of your remedy is the removal of the information that's being reported, or reported as paid in full instead, reported as on time, whatever you're telling them to do, as opposed to telling the credit reporting agency, because all they're going to do is tell you that the original creditor, the supposed original creditor, is saying that it's valid. So I rather go to the person, like I said, the source, make them do what I want them to do.
Right. Miss Olvin?
Alvin.
Oh, sorry.
Greetings, everyone, and thank you. So I just want to know, and thank you very much for what you guys are sharing. So I actually have been garnished, and I'm getting threatening calls from attorneys, and unfortunately, I never got served. I never got the opportunity to have my day in court, and I have to take off once a month in a day to kind of just make sure my name is on the docket. So my question is, how do I avoid being garnished again or being served? Not being properly served versus me just taking off of work and trying to check and making sure that my name is not on the docket at the county court. Like, what is the recommendations if they're threatening me but not giving my day in court?
So you're currently being garnished, or you're talking about they're attempting to garnish?
I have been garnished several times, but I'm not getting served. And so I got to keep checking at the county court office. I'm just figuring, I'm listening to everyone's questions. So I waited to see if you guys have any recommendations how to make sure they give you your day in court. Just give me the day in court so I can make the argument. And I'm not getting that opportunity. I'm just getting the threats. And then I get the garnishment.
So you are getting the garnishment right now. That's the part I'm confused on. You are getting garnished and getting threats?
She's been garnished multiple times, but in the pursuit of garnishment, she's never been served. They're threatening her, and then they're garnishing her. So not to just jump in, but I think I understand the question, so I'll attempt, and then Jessica.
Yeah, go for it, because I'm honestly confused by the question. I'm not catching it.
Okay, so what it seems like you need to do is you have to take action. So when they're threatening you, you have to respond, because no response means you agree. So silence is acquiescence. So when they're threatening you, you need to start your day in court. Court starts in the mail. So you need to start your day in court through some form of written communication to say, I dispute this, or this is not my alleged debt. I haven't been served properly. I don't know what you guys are talking about, something. So you have to initiate some communication back to them once you're being threatened. You can't just let them continue to threaten you, and then because they're not going to just give you your rights. You have to force them to give you your rights. If that makes sense. Okay, Kendra?
Yeah, you have to dispute it if it's not being done yet. I thought it was done already. That's what's throwing me off.
Yeah.
Yeah, you have to dispute it.
Hey y'all. Thank you, Jesse. Thank y'all. I really appreciate the breakdown in layman's terms. And I'm sure everybody else does too. But my question was, can we okay, I know we talked about going back and asking for our credit file. So like if we had things on there years ago, we can, because I know you said it never, fraud never expires. So we can really go back in life, and anything that we've done, we can do these processes, right?
As long as you can get proof, yes.
What you mean?
Like I said, well, you have to have some type of evidence, right, of the wrongdoing. If you don't have any evidence, it's going to be a lot harder to go at something from years ago. But if you do have the evidence, then you have somewhere to start. And like I said, with the verification, when you ask for that, say you've been paying it and you ask for verification, if they can't provide it now, today, and you've been paying it for years, then that means they couldn't provide it years ago. And that's why you request your payments back under 1692H.
Okay, well, before you start, because you already asked the question, so I'm gonna jump to Chris, and so we got to get everybody who hasn't asked the question yet first. So Chris, it's your turn. Well, you got to get back in the queue.
Hey, how you doing? I appreciate y'all. I got a quick question. I know back in 2018, I took out a loan, personal loan with the creditor, which is One Main Financial. And then like that next year, my daughter was in an accident. So it was a traumatic event. And I actually worked out with the creditor to put it in like a forbearance status based on the situation. Long story short, 2019, I went to the local branch, and what they did was took it out of that forbearance status, and I wasn't in a position to continue making the payments. So as of right now, I recently got a letter from the courthouse where I'm at, and they said that I have to appear in court this coming Monday from a portfolio. I think it's portfolio recovery. It's a debt collector. And I guess my question is, when I took out the loan, it was in a different county, and I live in a different county. I live in Charleston County, but the court that I have to appear is in Dorchester County, which is a different county. So how does that work? Is there any valid validity to that, to it being in a different county from where I took out the loan and where I currently live?
Well, it says that, this is your first time hearing about it then, right? So it says under, was it 1692G, I believe it says that does not count as communication. Your first communication cannot be on a lawsuit. Does that make sense? They're gonna, huh?
That's true. But if you realistically, because just because we learn the law doesn't mean they're gonna stop breaking the law.
No,
So,
definitely.
so you use the law that Jesse said because that's your right, right? But if it were me, because we don't give legal advice, we just give clarity of legal information, I would appear in court because they're not gonna stop that court proceeding if you send communication right now. I'm just letting you know right now. They're not gonna do that. It would take you being very fluent with the law, like your letter has to be fire for them to stop a court date. Or they would have to, so I would still appear, because remember, silence is acquiescence. So they're gonna take that like you didn't show up, you agree, and they're gonna do whatever they want to do. But when you go, definitely use what Jesse said.
Yep.
Yael, I hope I said that right. It's your turn.
Can you hear me?
Yes.
Yep.
All right. Yeah, you said it almost right. Yeah.
Okay.
I appreciate it. So my question is this. When asking for debt, for your verification of your debt, when you're asking, let's say, a previous debt, something that you've maybe paid off in the past that may have some fraud or has some fraud, is that how you would go about that? So like say like a car loan that I've already paid off, but I know there was some fraud in it for sure. Would I go directly to them, let's say Santander or somebody like that?
If that's who you were paying, then yes, you can do a notice of dispute at any time. It's upon your discovery, right? None of this stuff was disclosed to you. So now you can ask for it, even though you have paid it off. And if they can't provide it now, like I've been saying, that means they couldn't provide it back then. So pursuant to 1692H, you're demanding and directing them to return your payments as part of your remedy. And I know we're not in truth in lending, this is in the FDCPA, but under truth in lending, the 15 USC 1640, where it talks about civil liability, it mentions that if they did not give you proper disclosure and you have to enforce your rights, they're automatically liable to you for double the finance charge. So you could add that in as well.
Y'all see how y'all just got some extra sauce? This ain't even truth in lending class.
Yeah.
Okay, now, Angelus, I believe you went already before. You had one question before, so I'm gonna get to Timothy, and then we'll cycle back if everybody's questions have been answered. But we're not gonna be here all night, y'all.
Everybody's already been. I don't know about Angelus, honestly, but
No, Angelus, because I remember saying that. But Timothy, I don't think we got to Timothy. And then Savage Dog was the first one in line to have a second question, but we're gonna go to Timothy first. So bear with me. Timothy?
Yes, thank you. Jesse is correct. I did go once, but I do have a quick question if you allow. And that question is, how do I remove?
If you went once, we got to be fair. I said I would start with Savage Dog. So, because she was the first person to raise her hand again after asking one question.
Right now, I have to step away. I got to use the restroom real quick.
All right, we're going to give Jesse a break so he can take care of his business. And then when he comes back, we're going to cap it at, what time is it? 10. We're not going longer than 10:30, y'all. So, and make sure, so I seen some remarks in the chat, right? Because I don't miss much. And I got moderators. We're going to keep it cute and we're going to keep it classy. Now, I told you in the beginning, we was asking one question. We don't have time to clarify for 15 minutes. When you guys are formulating your questions, I'm gonna need you to know what you want to ask, okay? If you find it rude that I cut you off, I can't help that. We got 78 people in here, okay? I love each and every one of y'all, but we do have to be fair, okay? So, and my brother taught a whole class and now he's answering questions. So we want to be fair to our teachers as well. We want to make it mutually beneficial for everybody. So please do not take it personal. A lot of times by listening to the other person's questions, you will definitely get your question answered. So yeah. We're gonna do it like that. So I'm gonna go. I see a lot of repeats up here. So what I'm gonna do is I'm gonna go to Savage first, then I'm gonna go back to Timothy, and we're gonna go across my screen. So I'm letting y'all know now. It's gonna be Savage, Timothy, Melissa, Robin, Will, Corletta, then Mia.
All right, I'm back.
All right, we ready?
We still got to do the giveaway of the 2 tickets.
Oh, I forgot. Okay, so Mia's the last one.
Okay, I didn't hear the order.
Wait, let me see. We just got 2. Okay, y'all got to keep it short. We just these 2. Okay, so we're gonna do all this up here now, no more. So we're gonna stop at Angelus. Okay, so we're gonna go Savage first, and then I'm gonna go Timothy, Melissa, Robin, Will, Corletta, Mia, Karina, Angelus. That's it, y'all.
It's a long list.
Look,
right? But
if y'all want to keep answering questions, we ain't giving away tickets. If somebody want to win a ticket, we gotta cap it. Let's go. Savage, you're up.
Okay, so this is a short question. Jesse, with the right to rescind, I wanted to, and I know you said this before that I think you don't, but anyway, I wanted to use the FDCPA with Tilla just because I feel like with the debt collector, the meaning of it, I feel like the car dealership is a debt collector. So I want to use some of the FDCPA with my right to rescind. My question is, what do you think?
If you included the FDCPA, well, I would also, I don't know what your level of understanding is of the right of rescission. A lot of people mess that up, but all I can say, so I can't teach that. That's like a whole, not a class, but it's a whole section of time on its own to make sure that somebody would have proper understanding about the right of rescission. But I would say, keep in mind of the verbiage, you are not rescinding the contract. You are not rescinding your signature. You are rescinding the transaction. Make sure that you keep that in mind. That is what you are doing. Now, as far as for your reasons for rescinding, you could use the FDCPA, but I would recommend staying more in truth in lending. That's where more of the power is, because they did not provide the disclosures that are required, and they did not give you clear and conspicuous information. So stick in truth in lending mostly, but yes, you can also use the CPA.
Okay, Timothy, your turn.
Thank you again. So how do you remove the automobile from the dealership once you've done all the proper paperwork without doing the registration and the insurance? Should I use a tow truck? Because the registration will put the state into a type of ownership as well of that vehicle, and that's not what I want to do.
So talking about like an MCO type of thing.
MSO.
MSO.
Yeah, I want to
So,
retain full control over the automobile and have full equity and legal ownership.
Well, yeah, once you have it physically in your possession, you already own it. And especially if it's already paid off and you have the title, they're not going to just randomly come and take that from you, from your house or anything like that. That's extra steps that I honestly haven't even looked into, the MSO or getting that or obtaining that. But getting your car is a private transaction. It does not have to be a commercial one, right? We have a right to travel. So it does not have to be a commercial transaction where you're subject to the taxes and fees of the state. But as far as the MSO, I have no idea. It's not even something I've looked into getting, I'll be honest with you.
Melissa?
Would IRS debt be treated, debt and wage garnishment be treated differently than these collections we're talking about?
What does the IRS do? Their main job is debt collection. They're just one giant debt collector. And their system is voluntary. So they're actually collecting on you, and it's a voluntary system, but they have all of these penalties that come along with it. So the only time that somebody gets treated different as far as debt collectors or corporations is because we view them different, but they are not different. They're still just a piece of paper like the next one.
Okay, so, Robin, yes, Robin. You gotta unmute yourself.
Yeah.
Okay, there you go.
Hey, greetings and peace, loved
Peace.
ones. Hey, so my husband has a question.
Yes. I have a situation here with the townhouse where me and my wife are staying with my daughter. And all of a sudden now they're giving us like a 30-day to vacate. And they're saying that we have a back bill of over $10,000. And I'm like, that can't be right, because they were adding all these late charges, even though when we would pay, say the middle of the month or the end, we would still pay, but they accumulated all these late charges. And I did call my congressperson, and they were saying they are not to charge you any late fees during the pandemic, but they have them in here. So now it's under a new ownership. So they want me to vacate the premises in 30 days. But then they do have something on here else about notice to let you know about the about my rights to participate in the city hall. Is that Philadelphia free eviction diversion program? So they have things like that in these letters. So I just want to know what's the best remedy that we can deal with in dealing with these landlords?
Refuse to pay.
It sounds like you need a consultation.
Yeah, that's a lot going on, but when you only have 30 days, you know, it really depends on your understanding of the law. And unfortunately, the law doesn't move at our emergency, at our need, you know, so, but you definitely have to do something, whether it's notice of dispute. And if you can get that in writing, what that congressman said, then that can be evidence as well. But yeah, that's a whole lot. That's a whole lot to unpack in just one question and give you one answer. There's a lot of different variables as well that come with that. But if that congressman that you spoke to, that you're saying they said they cannot charge you late fees, try to see if you can get that in writing like ASAP. Because that could be an exhibit. Because if that's all it is, like you're saying, is late fees that added up, then they can't charge you that.
Well,
hey, real quick, I just had another question on the rights of rescission. I believe you were the one that got the free car. Did you have to go to court for that, or like as far as that?
I sued for that. I didn't get to go to court. I went to arbitration to get the title, and then they motioned for mediation instead. So I haven't even went into arbitration either. I'm awaiting settlements. Hopefully, you know, by the next week or so, because the mediator already accepted the case, gave us his schedule, and was like, hey man, I'm good to go. We just need to set this up. So I did have to hit that point of suing, yes. Did I use fair shake?
Mia?
No.
Mia?
I seen Richard wanted to ask a question. I was gonna give up my spot for him.
Okay, Richard. Hurry up and unmute, Richard.
I know you got a spot you weren't even supposed to have. You better jump up here.
Yeah, look, we got 10 minutes. I said 10:30. We still got a giveaway. All right, Karina.
Hello, thank you. Okay, so by reading my lease contract on my apartment, it says that by signing the leasing agreement contract, I waive any immunity that may be available under the Foreign Sovereign Immunity Act. Is this lawful?
You can never sign away your rights.
Okay, great. Thank you so much. Thank you, thank you, thank you.
No problem.
Angelus.
Hey, so before I found you guys, I did a dumb move and I actually sent letters with the FTC, you know, fraud report to the CRAs. Now I want to do this method and go, you know, with the, you know, debt collectors directly, but like one of the CRAs already came back, one of the debt collector validated, and so I'm wondering, should I still go and scratch everything and just do FDCPA with the debt collectors, or can I guess I'm trying to understand if, because I did the FTC reports, if I should add that to my letters to the debt collectors. I already did their own verification, which it wasn't really the verification that you guys said.
Mm-hmm. So you have an FTC report, so an identity theft report against the debt collector. Is that what you're saying?
So I think I get what she said. You, first of all, because we can't ask clarifying questions at this point. You can go back and redo any steps you think that you need to do. So there's no real wrong answer for a consumer. It might prolong your remedy, but you can always switch it up. So if you feel like you did something that wasn't as effective, you can then try to do something else in place of that, or in lieu of that. You can pseudo start over if that's what you feel like you need to do, if that answers your question. But this speaks to a bigger problem that I see that a lot of people have, which is putting the cart before the horse. So if you are not ready to move to the next step, if you don't even know what the next step is, you should not start enforcement. So this is an over life thing. We're not in a hurry. And I know that sometimes you have an adverse action that's happening to you. But most of the time, you're going to have to get them on the back end, which would probably be better for most people, cause you less stress than to start something, be in the middle, get flustered, and they're going to do what they want to do anyway. So literally studying is your best friend. If you're not sure what law to use, you need to study. If you don't understand how you can use FDCPA, FCRA, truth and lending interchangeably and in conjunction with one another, you need to continue to study. And I'm not saying that to be funny. Really, we love you. We don't want you to do anything that's going to put you in a situation that's worse than what you're already in. That's not what we're here to do. Sorry, Jesse.
No, you good. You nailed that you hit that right on the head. So study. And yes, you can always start over, like she said, or just, pivot. All right, cool. Let me do this now. It's really up to you. And like I said before, we only lose once we give up and we let them win. Otherwise, we can never lose.
D, I'm gonna let you in because I don't think you asked a question. After D, we're going to
You said 5 minutes. They're counting down already.
They are, because I told them 10:30. That's why y'all my people.
Thank you so much. I don't know why my hand wasn't showing as raised. It looked like it was to me. This question is, American Express got a judgment against me. In the process of, I filed a motion to vacate it, but can I just start over with them and just start disputing the debt? Or, how would I do that?
Yeah, this sounds very similar to the last question, where you can always start over if you need to, or pivot, just change the perspective a little bit as you need to, as long as you can articulate yourself and continue to put pressure on them, you'll be fine.
And also for the people who have court dates that are like coming up pretty soon, if you don't have time to do the things through the mail, you can still do the things in person. So when you get to court, you can ask questions. The simplest thing is something that we usually overlook. You can ask for your validation. You can ask for a competent witness. You can ask for Discover or whoever to present themselves. Where are they at? You can ask questions. Who is this person? That's not Capital One. I don't know who that is. I didn't do it. I didn't do any consumer credit transactions with this person. This person was not present at the time that I entered into this consumer credit transaction. XYZ. So if you have to go to court and you don't necessarily know the laws that well, you can still do whatever your dispute letter was going to say that you didn't get a chance to mail because you got court in like a week. Go to court and ask whatever it was, or say whatever it was you were going to say in your dispute letter. The most important thing is to respond, to act.
I hope you guys, go ahead.
No, I'm done.
I hope you guys caught what she said, a competent witness. A competent witness means that they have firsthand knowledge. They can't provide, they don't have that. So just by asking for that is powerful. And then whoever they send, you'd be like, like she said, who the hell is this? They weren't there the day that I was there. I'm the only person with firsthand competent knowledge. That's all the questions. Finally made it to the end.
Yes. So now my brother is going to give away.
Man, I haven't. Oh, and another thing too, for the people who don't get the giveaway, right? I don't know if you heard earlier when Vernay said we have a coupon code that's only for the people in this class or whoever purchases the replay. That is Big Bully, all caps, and it takes $100 off the ticket. So it's $555 right now. It'll be $455. $100 off just by putting in Big Bully as the coupon code. Know, damn, I feel like there's a lot of pressure. Like, who am I giving it away to? So, obviously, whoever I choose, if you know that you cannot make it there, let me know so that somebody else could possibly win. But there's still a lot of time to figure that out. So I would suggest just trying to get in. So the first person that I know for a fact I'm going to choose is Mia Moore, because she gave up her spot. And that was selfless of her. So
big consumer-ish. Mia, you coming to do for self? You got a free ticket. Well,
got
let
a
me say,
free
you
ticket
got a free ticket. So one of
to
my
the event.
moderator, if you could write down, if you could write down her name, message us in the Facebook group or on Instagram, Mia, to give us all of your information so we can get you squared away.
Mm-hmm. And that is not a lodging ticket, though. Keep in mind, you need to get the hotel, but you're going to be able to go to the event. I just want to be clear on that, so nobody thinks that they're going to be getting lodging, because that's not what it includes. And damn, I don't know for the second one. Let me see. I'm just gonna scroll through these names, just see who I land on. Just trying to see. Let me find the person that needs it most. I hope that that works out for me. And some people left.
Don't look at the chat. Don't look at the chat.
I'm not looking at the chat. I'm just scrolling through names, because I already know they're gonna start pulling on my heart, trying to ask me. But some people left too. We're like 4 people down, so you guys got lucky. You lost some of the competition. Let me see. Is that who I want to say? I guess Marcus Ward. Are you able to do for self?
Marcus Ward, you got a free ticket to do for self. If you know now that you're not gonna be able to make it, say up, speak up. We got, it's 10:30. Well, 1 minute.
1 minute. Marcus Ward, I don't know if you can't make it.
He said thank you, so I think he's claiming his ticket.
Yeah.
What we'll do though is, for the 2 people that were chosen, if you can't make it for some reason, we'll give your ticket away in the Facebook group. So all of y'all need to be in the Facebook group. And
Definitely.
I'm gonna do something real quick because I feel it in my spirit.
Here we go.
And I'm gonna give Richard, whoever Mia was trying to give her seat to, I'm gonna give Richard a ticket. So Richard, whoever would hit us up, send us the information. Richard's gonna get a ticket. Now remember, you have to get yourself to Atlanta. You got to get yourself lodging, because lodging is closed. Okay, but you have a free ticket, and we will be feeding you at Do for Self. So you'll be at ease something. We're gonna feed your soul and your body, God willing.
And then for everyone else, you still want tickets, use the code Big Bully. It takes $100 off. Keep that in mind. And to close out, what I'm gonna say is thank you guys so much for trusting me to give you clarity. It truly means a lot. This class was full. I hope that you walk away full, that you got the clarity that I intended to give you. Please continue to study. Like I said before, do not read the law just to say you read it to completion. Read it to comprehend it and understand it. And do not get mad at yourself for not understanding it right away. The national reading level of the United States is between 7th and 8th grade, and that is intentional. We were intentionally taught the wrong definitions of words. We're intentionally kept at a lower reading level. And these laws are written in a way that is intentionally difficult to understand. It is intentionally confusing if you don't know who you are. Please take your time with yourself. Be patient. Step away if you have to, but never stop. Always come back to it. If you cannot do it, then it's your kids that are going to do it. If your kids cannot do it, then the next generation is going to do it. But it's going to come from the few of us putting in this work, the many will benefit. If I do not live a completely consumer lifestyle to its fullest extent, I bet my kids will.
All right, y'all. Thank you so, Jesse. You never cease to amaze, brother. I am so grateful and fortunate. I'm grateful to the Most High to be in your company, to call you my brother. I learn something every time I hear you teach. I know they did. Everybody join the Facebook group. Yeah, we'll see you guys over there. Peace and love, everybody.
Peace.
And on that note, you ain't got to go home.
But you got to get out of here. No.
Peace and love.
Peace.